Good afternoon, Mr. Arbitrator. My name
The game's disciplinary committee is quorum and a fourth issue on the
is Mr. Lander's issue on appeal. My co-counsel, Mr. Brendan Zhang, will be speaking on issue 2 on a location of the tribunal and issue 3 on Ms. Tang's admissibility, addressing Ms. Tang's issue on appeal. We respectfully reserve 1 minute for our sir rebuttal. This case is not about sympathy for one athlete or the popularity of another. It is about upholding the rules and integrity of the qualifying games. The GDC acted within its mandate, applying the governing rules and principles to protect fair competition and ensure that the games are conducted without illegality or undue advantage. With that, I make two submissions addressing Mr. Lander's claims. Firstly, the GDC's quorum was not biased in coming to a decision, as both Ms. Farina and Mr. Douglas are independent and impartial arbitrators. Secondly, the GDC did not err in finding that Mr. Lander had been liable for doping. Bluebet, in its nature, is a performing enhancing drug. Turning to issue 1, while the appellant may seek to rely on Rule 33, this is wrong. What Mr. Lander intends to do is to challenge an arbitrator, as seen from para 37 of the record. To determine if an arbitrator should be challenged, the applicable rule instead should be Rule 34 from the Code of Sport-Related Arbitration, hereinafter the CES Code. Rule 34 states that an arbitrator may be challenged if the circumstances give rise to legitimate doubts over his or her independence or over his or her impartiality. This threshold of legitimate doubt can be similarly found in Malaysia's Arbitration Act Section 14.3 Part A. The threshold of legitimate doubt is similarly noted in Article 180 Part 1C of the Swedish Federal Act on Private International Law, hereinafter the Pillar. This demonstrates that the evidence of biasness must be justifiable and concrete, and this threshold has been applied stringently to related cases. The high threshold of concrete facts has been illustrated in the 2020 Swiss federal case of Sanyang and World Anti-Doping Agency. The courts noted at paragraph 6.5 that there must be concrete facts objectively giving rise to the lack of independence. Turning to our case, at paragraph 4 of the record, Ms. Farina is described merely as Ms. Tang's cousin sister. While this indicates a blood relation, it is a relatively distant one, and there is no evidence in the record that suggests any meaningful or personal emotional bonds between them. The absence of any indication of frequent interaction, shared household, or personal involvement beyond this genealogical link supports the inference that their relationship is more nominal than substantive. In disciplinary or adjudicative contexts, such as the one we are facing here, a mere familial connection without concrete evidence of closeness does not, in its own, give rise to a reasonable apprehension of bias. Moreover, although the record at paragraph 4 mentions that Ms. Farina had provided some side coaching, this should be viewed as a limited and informal engagement. There is no suggestion that she held a permanent coaching position or received remuneration. Such ad hoc or casual assistance, perhaps in the form of general sporting advice or occasional tips, does not amount to an entrenched professional association which would compromise impartiality. It is plausible that Ms. Farina's involvement was situational, incidental, and peripheral to Ms. Tang's competitive endeavors. Taken together, the tenuous familial link and limited scope of professional conduct point towards a relationship that is neither close nor influential. There is therefore insufficient basis to conclude that Ms. Farina's role on the commission would be tainted by personal loyalty, dependency, or biasness to Ms. Tang's. Turning now to Mr. Douglas, the professional interactions such as the fan meetups as seen from para 26 of the record, where both Mr. Douglas and Ms. Tang's were spotted together, are typical of public figures in the esports realm and do not indicate a privileged or adversarial relationship that would compromise his judicial capacity. The one-time special and personal sharing session, which the appellant seeks to rely on, was an event that took place 6 months prior to the tournament, as seen from para 26 of the record. A single historical event, even if it led to them being in contact since, does not establish an ongoing dependent relationship that will necessarily sway his judgment regarding the complex legal issues of doping or eligibility. Secondly, even if there was a finding of a relationship, there must be ongoing economic ties or ties that have ended recently to demonstrate a lack of independence or impartiality. This was noted in the 2015 case of AVB heard in the Federal Supreme Court of Switzerland. At para 2.2.1, they emphasize that impartiality and lack of independence is only found if there are ongoing economic ties or ties that have ended recently. In our case, there's clearly no economic ties between Miss Farina and Miss Tangs, as they are merely distant family members, in which Miss Farina only acted in the capacity of a coach, as seen from para 4 of the record. Noting that Mr. Lander is the one alleging the presence of a lack of independence, the burden of proof would be on him. With respect to Mr. Douglas, there's only a coaching relationship as well as seen from para 26 of the record. While their relationship did eventually get closer, there's still no evidence of any economic ties of which Mr. Douglas will have a profit from ruling in favor of Ms. Tanks. Therefore, the GDC submits that its quorum was not biased in coming to a decision, and its decisions should henceforth be upheld. Turning now to the second issue regarding doping, we submit that the Games Disciplinary Committee did not err in law. Our submission are structured into two main submissions. Firstly, the GDC acted within its jurisdiction in finding that Mr. Lander committed a doping violation under Rule 12 of the qualifying game rules, henceforth the QGR. Secondly, the GDC's decision was consistent with CEA's jurisprudence and Lex Sportiva principles. On the first argument, Rule 12 in the QGR defines prohibited substance as any substance or method contrary to the spirit of sport. This clause grants GDC the residual discretion to protect sporting integrity even for unlisted or newly discovered substances. I note that there's no outright definition of spirit of the sport. However, this is specifically noted at the WADA Code at page 13. The spirit of the sport is a celebration of the human spirit, body, and mind. It is the essence of Olympism and is reflected in the values we find through sport, through the value of excellence in performance. Putting this in context of Quidot, it is essentially an e-sport where concentration and focus is the key to winning. This is something that Mr. Lander knows very well, with himself coming in clutch in draw-breaking games, as seen from para 6 of the record. As seen at para 12 of the record, in the final match between himself and Miss Tanks, such a close game is extremely close and extremely tiring on the eyes and mind. Therefore, the player who deserves to win is the one who is able to, without doping or any other form of assistance, focus all the way to the end. However, Mr. Lander was only able to win with the assistance of Bluebat. Knowing that Bluebat could keep his energy up, he kept them nearby as seen from para 12 of the record. Miss Tanks, with her dominant performance as seen from para 11, was bound to have won the tournament, if not for Mr. Lander's intervention with 5 points. This concentration enhancing drug, i.e. Bluebat, essentially allowed Mr. Lander to take the edge over Miss Tanks as seen from para 13 of the record. Therefore, his actions goes against the core of rewarding players' excellence in performance, which is against the spirit of the sport. Rule 13 of the QGR instructs that athletes are to refer to the WADA prohibited list. However, this term merely signifies guidance rather than exclusion, and does not preclude the Commission's authority under Rule 12. Therefore, the Commission's reliance on Rule 12 is neither arbitrary or ultra-virus. Consequently, the GDC's decision to sanction him for conduct contrary to his spirit was within its jurisdiction and consistent with its mandate to protect fair competition. Turning to our second argument, the GDC's decision was consistent with CEA's jurisprudence and Lex Sportiva principles. In the 2004 CES case of Maria Louis Kelly Williams and IOC, the tribunal accepted that an unlisted substance could still fall within the scope of the code if it exhibited similar pharmacological effects or violated the spirit of the sport. Professor Caitlin's expert report cited at para 3 of the judgment, concluded that though not expressly listed, the substance had a similar pharmacological effect to other prohibited stimulants under Article 4 of the IOC rules. The panel accepted that anti-doping authorities could act on such evidence to preserve fairness. Analogously, Bluebear enhanced concentration and alertness in competition, mirroring the very harms that anti-doping rules seek to prevent. Furthermore, the 2005 case of US and Balco noted that addressed such issues regarding newly found performing enhancing drugs. And its judgment is pertinent in understanding the nature of Bluebear. I quote, "It will be impracticable to identify all forms of steroids in a list prohibited substances, and that restricting the prohibition to certain named substances will be both unfair and detrimental to sport. This reasoning directly supports the GDC's proactive stance by developing Rule 12 to function as a catch-all clause should be upheld. Applying these principles, the GDC's decision was reasonable and appropriate. Bluebear, while not yet on the WADA prohibited list, demonstrably enhanced cognitive focus and stamina, creating an unfair advantage. Accordingly, with the application of Rule 12 of the qualifying game rules, the GDC did not err in finding that Mr. Landert had committed a doping violation. In conclusion, in response to both Mr. Landert's issue on appeal, the GDC maintains that the quorum was not biased and that the GDC was correct in ruling that Mr. Landert had committed a doping violation. Unless I may be of further assistance to the bench, this concludes my submissions, and I'll hand over my time to Mr. Brendan Zhang, who will address the remaining issues. Thank you.
Thank you, counsel. Members of the tribunal, my name is Brandon Zhang, and I appear for the respondent, the Games Disciplinary Commission. I'll be speaking for 14 minutes on issues B and C, on the issues of whether the GDC erred in allowing the tribunal to set up in South Nankaland, and whether the GDC erred in deciding Ms. Tang was ineligible to participate in the qualifying games. Turning to the first submission, it is submitted that GDC decided properly and correctly in allowing the tribunal to be set up in South Nankaland. We submit that the seat was validly chosen in accordance with the agreed upon rules, and that it was practically necessary given the riots in the host city of Rambutana, and no prejudice or unfairness resulted as per the decision. Members of the tribunal, the applicable law to the merits of the case fall under Rule 45 of the CAS Sport Code. The rule states that the panel shall decide the dispute according to the rules of law chosen by the parties, or in the absence of such choice according to Swiss law. The parties may authorize the panel to decide. Mr. Arbitrator, this rule establishes the freedom of the parties to apply the substantive law of their choice. Mr. Arbitrator, the law governing this dispute, therefore, pursuant to Rule 45 of the CAS Sport Code, is governed by Malaysian law, per the record. And in the Malaysian Arbitration Act of Section 22, subparagraph 1, it states the parties are free to agree on the seat of arbitration. In paragraph 2, it states, where the parties fail to agree under subsection 1, the seat of arbitration shall be determined by the arbitral tribunal having regard to the circumstances of the case, including the convenience of the parties. In the present case, if I may direct the tribunal to the record at paragraph 29, it states that Ms. Tang disagreed on the location and that it was not suitable for her. There is First of all, no evidence that she produced of why it was not suitable. And secondly, she merely said it was not suitable. This does not mean that it was inconvenient for her. And moving on to subsection 3, notwithstanding subsection 1 and 2, the tribunal may meet at any place it considers appropriate for consultation amongst its members. And therefore, that is exactly what the tribunal did. And pursuing to the qualifying game rules of 23, rules 23, subparagraph 2, which requires the disputes to be heard in any country where practicable and within a week in the host country where reasonably practicable. The agreement was entered into, implied as the athletes entered into the tournament. It incorporated these rules, and participation alone constituted the implied consent that we need here, members of the tribunal. In the 2008 Matsuzalim versus FIFA case, a footballer challenged the sanctions after breaching a contract, and the tribunals at paragraph 4 to 6 explain that the seat determines the lex arbitri, the national law of the arbitration, but crucially that the parties' agreement on procedure is controlling. And just as the CAS enforced the parties' chosen framework in that case, in the present case too, the athlete's implied consent by entering into the agreement is in accordance to Rule 23, which is a flexible seat clause in the tournament agreement. And similarly, in the 2011 CAS decision of Fushi Malohi versus FIFA, a FIFA official appealed a corruption ban. Nonetheless, CAS upheld a non-Lausanne seat because the parties were deemed to have been under FIFA rules. And by analogy, in the present case, Rule 23 is the same. The athletes are deemed to have been under the qualifying game rules. And therefore, the GDC did not err in its decision. Now, secondly, the seating the tribunal outside the host country was necessary. The facts are clear at paragraph 25 of the record, if I may direct your attention there, Mr. Arbitrator. The riots occurred 3 days after the tournament. For 3 days, massive riots broke out into the city of Rabutana. Now, this is inside the 1 week window. Now, opposing counsel might argue, well, why did they not schedule the hearing on the 5th or 6th or 7th day? Well, it's not exactly practicable or safe to go into a city merely days after such massive riots of destruction and civil unrest. This is still unsafe. And therefore, we submit that the GDC correctly determined the location of South Nankaland to be a valid location. And furthermore, it was practically reasonable as well. And it was at convenience. Well, why? That is because it was in the headquarters where the global games are at. This is at the heart of the dispute, and merely the fact that it's there at the global headquarters games itself does not give rise to any impartiality issues or unfairness or bias. To assert so to argue otherwise would just be bare assertions with no evidence. In our case, nothing in the record shows that the South Nankaland seat affected impartiality. The procedures were transparent, and the appellant cannot pinpoint any structural defect or any issues in procedural unfairness. And furthermore, it is noted that Mr. Landa himself did not contest the location at the time, as seen in paragraph 29. And this undermines any claim of prejudice. If the party that was most affected did not object, how can it be said that the seat created unfairness, especially when the relocation was for safety and was communicated to all the parties in advance? And pursuant to paragraph 29 of the record, it's also an Oceania country. And Ms. Tang is also born in an Oceania country. Therefore, we submit that the GDC acted properly in seating the tribunal in South Nankaland. Turning to the second submission, we submit that the GDC, the Games Disciplinary Committee, found correctly Ms. Tang was ineligible to participate in the qualifying games. Under Rule 3 of the qualifying games, representation requires a real and effective connection to the nation entered, and Ms. Tang lacked that connection. The rule states that it requires athletes to be citizens or permanent residents of a country in Asia. Members of the tribunal, I must first address the issue of interpretation. CAS jurisprudence has emphasized that while it's not a rule maker and it doesn't rewrite the rules, but it must interpret the rules to that of which gives intention to the rule maker, to give the purpose of to the rule maker. In the 2009 Telecom Egypt Club versus EFA at paragraph 33, the panel concluded that it interprets the various provisions in a manner which seeks to discern the intention of the rule maker. In the present case, the GDC correctly interpreted Rule 3. The intention of the rule maker for the qualifying games was very simple. It was for the games to be represented by Asian athletes who were citizens and permanent residents. And what is a citizen and what is a permanent resident is somebody who has lived recently for an extended period of time with an allegiance to the country. Therefore, we submit Rule 3 was interpreted correctly and discerns the true intention and purpose of the rule maker. On the second point, we submit that Ms. Tang had no close connection to the country of Duriana. And in the 1999 CAS decision of International Baseball Association advisory opinion, at paragraph 27, the panel said a person may have two or more nationalities, but every athlete can only have one sporting nationality. A sporting nationality, Mr. Arbitrator, is essentially the genuine, authentic allegiance that an athlete has with his country, representing his country. In CAS decision, Mr. Angel Perez versus IOC, at paragraph 17 through 20, the tribunal cited the 1953 ICJ Liechtenstein case versus Guatemala. In that case, Mr. Nottenbaum, who was a German national, settled in Guatemala. However, while on a trip to Europe, he obtained Liechtenstein nationality and returned back to Guatemala in less than a year in 1940. When Liechtenstein claimed restitution from the government of Guatemala towards Mr. Nottenbaum, the ICJ court held that Mr. Nottenbaum's nationality was not based on any genuine prior link with Liechtenstein. At paragraph 18, in Mr. Angel Perez's case, the court agreed that Guatemala agreed that Mr. Notenbaum did not have effective Liechtenstein nationality for this purposes. And this shows that the court jurisprudence has effectively agreed that while an athlete might have a legal nationality-ship, that is very distinct from a sporting allegiance nationality. And on the facts of the case, in our case, she merely simply moved back into the country. She had recently moved back into the country at paragraph 19 of the record. And for some reason, she prior to this, she had actually lived in the country, but now moved away and now recently came back. In the CAS decision in the 2007 Melanie Rinaldi versus FINA case, the panel affirmed that in order for a real change and to prevent what's called nation shopping, residents need to correspond to the center of the athlete's activity in terms of everyday life, training, and competing at national level for a sufficiently significant period of time to establish that the new residence is not fictitious. And this was said even though she previously lived in the country with her grandma and her aunts, but had left to the US for a number of years to continue with her education. This was still the jurisprudence of the panel in that case. Furthermore, and in the present case, we submit that there is no sufficiently significant period of time recently to establish that Duriano was Ms. Tang's new residence. And merely because Ms. Tang has a citizenship in the country does not mean that she had a genuine connection or nationality to the country. And furthermore, at paragraph 3 of the record, it states that she is a popular streamer and she could easily have merely switched alliances to join this country in gaining more followers and for more economic benefits, such as streaming purposes for additional income and etc., and for new fame, according to the record at paragraph 3. On the totality of the evidence brought upon the court, we submit that the GDC did not err in its decision and that she is not eligible to participate in the qualifying games. We therefore submit that Prayer C be dismissed and the Games Disciplinary Committee's decision be upheld as consistent with CAS jurisprudence and the spirit of genuine national representation. If I may be of further assistance, members of the tribunal, this concludes my submission. Thank you.